Professor Carrier, some argue that the issues of evergreening and patent thickets are largely non-existent myths. Is that an accurate characterization?
No, it is not.
Could you explain that further to me so normal people could understand what that means?
Sure. So the patent system is designed to promote innovation, and we should be grateful for all that the pharmaceutical industry has done to promote innovation. But when you collect a whole bunch of patents and then use it in an abusive way, I think that is a problem. If I can take just a second, we've heard a lot about terminal disclaimers. It's a bit wonky, tough to understand what that is. Let me give you one concrete example. So Eylea is a drug that treats an eye disease, and Regeneron here sued Amgen in a patent over Eylea. The patent had a buffer that controlled the acid and ensured safety. The biosimilar Amgen did not have the buffer. In other words, it did not infringe. Court said, you're fine, no injunction, keep doing what you're doing. The very next day, Regeneron went back to the drawing board, got a new patent, new terminal disclaimer, and sued him again. They didn't have it in the first place. They got the idea from their competitor, and they filed another lawsuit. This is not about innovation. This is about playing games with these terminal disclaimers.
Ms. Simpson, do you have a thought on that?
I do. I think one of the things that's important to bear in mind with this idea of repetitive lawsuits that Professor Carrier just mentioned is that courts have a lot of doctrines specifically to deal with repetitive lawsuits. Issue preclusion, claim preclusion, and if they're not dismissing those cases on these grounds, it means these cases aren't truly duplicative. It means someone is going to court with a different enough property right that it's worth pursuing. And I think this goes back to an even more fundamental point that civil litigation is, especially in this space, it's complicated. It's due to choices that both sides make. And I think having, and to that end, I don't think there's actually, again, I don't think there's a real problem here to be solved that the courts themselves don't already have tools to deal with.
Some argue that the U.S. patent law makes it too easy for brand manufacturers to prevent generic and biosimilar competitors from entering the market. Would you agree with that thought?
I would not, and for this I go back to the data that shows that generics enter the market on average between 12 to 14 years, which is less than the length of a term of a patent, and that number is held steady for about 30 years. So I think if there were evidence that it were harder for them to get on markets, we would see it. 90% of prescriptions are filled by generics. We have an extremely robust generic industry in this country, which we should be proud of, but that's because the system we have is working.
Thank you. Ms. Good, go ahead. I see you have something to say.
Yeah, I just want to give an example. So there was a patent which was a method of purifying a drug. And the method was you put it through column A, then column B, then column C. That was shown to not be new. The patent was cancelled. Then the duplicate came along. The duplicate patent said you put it through column A, then directly through column B, then directly through column C. This one word difference, the word directly then needs to be litigated again. And when it comes to judges narrowing down claims, that takes years. So that's time when patients abroad are getting the drugs and patients in America are waiting for the patent litigations to be resolved. We're talking about a difference between a human and a patient in two different patents that would be rejected by the Patent Office if they weren't filing terminal disclaimers. The Ethic Act does not weaken patents. It encourages unique patents. It stops clogging up the system with repetitive patents. The branded drugs would not lose anything other than the ability to game the system.
Thank you. I yield back.